What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're looking back in on the Fraser Bohm case where Alan Jackson is asking the court to get rid of the most serious charges and to try and make this the appropriate charges for the actions and allegations of the state. So even with what the state says happens, this case is overcharged and the judge needs to step in and fix what the prosecutors have done wrong. That's basically what Alan Jackson is asking the court to do. He's going to make some very impassioned arguments and some analogies that I think some people may be uncomfortable with, but it's an interesting way to look at it. It's not always apples to apples, but I think it's good food for thought and good discussion points for us. And then at the end, we are going to hear the judge's decision. So it's not one that's taken under advisement, one that we have to wait until later. I have not watched the entirety of this argument, so it's going to be some initial gut reaction as it's happening real time. I've only seen a couple clips of it, so I'm looking forward to doing that together. And of course, answering all of your questions because you're going to have a ton throughout this. It's kind of a newer case that we've been following. Alan Jackson is a familiar name, but a very different set of circumstances that we have here. And we've done some overview videos on Fraser Bohm. If you want some background on to the facts of this case, it is based on a car accident. I'll call it a car accident where Fraser Bohm drove his car at a high rate of speed and killed 4 people. And we've done deeper dives into the overview if you want to go check those out before coming back to this one. But the serious charges, the M charges, could be over before they start if Alan Jackson is successful in this hearing. Let's get to it. All right, a couple things right off the bat. Number one, audio is not great in this courtroom. Don't worry, we are going to have the captions up the entire time. And I'll repeat a lot of the important things for the discussion points. You can hear it, so it's not like you can't hear it. It's just not the best audio, so I'm sure there's going to be people that have issue with that. That's number one. Number two, Court TV does jump in and like have their talking heads respond. We will skip through all of those, but if you ever wanted to watch those, obviously you can go and watch it on that channel. So without further ado, let's get to Alan Jackson, who is representing Fraser Bohm. Okay. Also, Jackie Sparagna, if you want to say it like you're from the South here. But Jackie Sparagna is one of the associates at Alan Jackson's firm. She is the female attorney sitting next to Fraser Bohm. She has done a lot of the briefing in this case. She may be the Elizabeth Little-like in this case compared to the Karen Reed case. Because she has been intimately involved in it and she's here in court. We'll see if she makes any arguments today or into the future. If you go to their website, you can check her out. And double grad from USC, obviously very accomplished and smart. I think she did moot court. So her briefing is probably top notch. That's what moot court usually is based on, and how you get on the team is from briefing. So we'll keep an eye on her as well and see what she does throughout the process. But Alan Jackson is the one at the podium. So let's take a listen into his argument.
Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission with all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. It starts with one truth, a legal truth here in California. Speed cannot be treated as malice.
Speed cannot be treated as malice. That is going to be one of the main components of his entire argument, that the only malice of forethought that Fraser Bohm had was that he was speeding. And in California, that is not appropriate and cannot go forward. Therefore, you have to dismiss those charges.
Speed cannot be treated as malice. That is the rule in the state of California. It's not made up by the defense. It's not made up by me. It's not a tagline. It's the rule of law.
All right, people. 2 people asked to slow it down. I'm never going to make everybody happy. Just FYI, I will slow it down one time. This will be the max that I'm going to slow it down. Can't slow it down any more than this. It's literally at 1.15 speed, so it's like barely boosted up. But it's the only way I can get through the whole hearing. So if you want to watch it slower, you can either slow down this video or you can go watch the hearing on normal speed. But if I don't do it this fast, I won't be able to get through the whole hearing. So I want to get through the entire hearing. I want to get through what the judge's ruling is and answer all of your questions throughout. Richard said if one juror believes that he was trying to get away from the guy in the other car, then wouldn't that at a minimum cause a mistrial for the M charge? So we're jumping ahead just a little bit, Richard. Doesn't bother me. Answer would be yes. It has to be unanimous guilty verdict. So if one person is a holdout for any reason, whether they believe the road rage story or something else, or just that the state overcharged it or they don't believe it, it could absolutely create a mistrial. It could be a situation where maybe they let them go forward on other charges, or we have to redo the whole thing again. Usually in normal courts, okay, in normal courts, if you have a mistrial like this, then maybe they would drop the top charge and just go after a lesser included. We saw that that's not what happened in Massachusetts. We'll see if eventually it happens here. Regardless of what the judge decides today, prosecutors can still change their mind and make decisions about charges in the future. So it's not over. This is not kind of a last chance effort, but this is to get somebody above the head of the prosecutor's office. I don't know if Alan Jackson has had an opportunity to present this to the new DA there, but the new DA could also step in, or the prosecutors making the charging decision on this case could change their mind. So there's still a lot of different things that can happen between now and trial.
In California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case has always required one thing and one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, not proof of recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements: an objective requirement and a subjective requirement. The prosecution has never satisfied either of those. Certainly not the preliminary hearing. And I want to be very clear right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Fraser Bohm commit that objectively involved a probability of death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this, was a tragic collision. But tragedy does not equal murder. And the law does not permit this.
All right. Had a couple people say Law and Crimes was better. We're going to jump over there once. You know, I try to keep the people happy. This will be, once we're over there, we're going to stay over there. So we'll see how it goes over on Law and Crime. Let me pull that one up here. Okay. Let's check out the Law and Crime, because this feed is terrible the whole time. We'll try this version, though, and see if it's any better.
Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice. And that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong, and they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed." They go on to say in the reply brief, in a two-page reply, in addition to speed, he also lost control of the car. Well, Judge, by definition, every crash involving speed is also going to include the loss of control of the vehicle.
So I disagree with that. And I don't know where this is going in because I haven't watched the whole thing, like I said in the beginning. But number one, I don't think every crash involves the loss of control of vehicles. And again, Darrell Brooks, just to use an analogy we both know very well, or all of us know very well, I don't think Darrell Brooks lost control of his car, even though there was a collision, a crash, an accident, whatever you want to call it. But I actually think the fact that loss of control of the car is a good argument that goes against malice just because you are speeding, right? I think that's important to consider when we're talking about the right charges. And I also think it's important to understand Alan Jackson is not arguing that all of the charges against Fraser Bohm should be thrown out, that this case should be dismissed, and that he didn't do anything wrong. I kind of feel like if I'm reading between the lines of some of Alan Jackson's arguments, that they might plead to something lesser included. They might plead to a crime. They might plead to a felony here for Fraser Bohm based on his actions and what resulted, right? Some kind of a negligent homicide, an accident, because that's what they're arguing it is. But as long as there is an M charge on the table, it makes all sorts of negotiating any plea deal very, very difficult because the state has the ultimate leverage at this point against a young defendant who has his entire life ahead of him. Now, obviously, he took 4 lives who were also young, who had their lives ahead of them. And that's what the state is looking at trying to balance here.
No crash. And then they throw in as almost a Hail Mary. And by the way, the defendant, quote, was aware that he did not have full control of his vehicle prior to doing so, end quote.
How can you be aware that you don't have full control of your vehicle? Is the defendant a Pepperdine student also? I don't know the answer to that. The victims were Pepperdine students, and I know Alan Jackson went to Pepperdine. I don't know exactly how far over the speed limit. They're still arguing about that, but he was going fast. Nobody's going to say he wasn't going fast. Zezalak said Aurora lights through most of the country tonight. For those who are interested, look through your phone if you can't see it. Isn't that interesting? Thanks for sharing with the class, Zezalex.
No citation, no quotation to the record, no citation to the transcript, nothing. Just a blatant, bald-faced statement with no foundation in fact. Where is the evidence? What evidence did they produce and present to the magistrate that my client, quote, was aware that he did not have full control of his vehicle?
Right. Like, did he say that? How would anybody else know that? It'd be pure speculation. By the way, did he use bald face again? He's just trying to teach us lessons that that's how you actually use it. So I'll take it.
Prior to doing so, prior to speeding, prior to the collision, there is none. They collapsed the 2 prongs of implied malice, as I just said, into one, and they applied pre-Reyes, and the court now is very familiar with Reyes, the 2023 version of CalCrim 520, both of which, pre-Reyes and the prior CalCrim, do not control. They are no longer the law. And the prosecution got the law wrong, and they argued the law wrong, and the magistrate, unfortunately, got that law wrong. The California Supreme Court's current rule on the objective prong of implied malice is set forth in the new 520 CalCrim and the cases post-Reyes. Before we go any further to the facts, the record, the evidentiary defects that were at the preliminary hearing, we need to start with what the Supreme Court has already started for us, and that is the Reyes case. Because if this court applies the law as it exists today, which this court must do, not as it existed before 2023, then the murder counts cannot stand. They are legally infirm. Period. Full stop.
And he is stating that as a fact. The judge is going to apply the law. Obviously, the prosecutors disagree, but a law change in 2023 makes this case completely different. TJ said Jackson's mission is not to avoid punishment altogether, but to make the charges fit the crime. Correct. Right now, yes. Right now, yes. I don't think just because if the judge dismisses these murder charges at the end of the hearing today, I don't think Alan Jackson's going to be like, okay, we're done. We'll go ahead and take that now that you've charged it correctly. I think he's still going to fight it, still going to battle it, still going to defend it, maybe negotiate a plea deal eventually. But I don't think that once the quote unquote charges fit the crime, as far as Alan Jackson believes, that he's just going to take some kind of plea deal. I think they're still going to fight this case regardless, but this is step one in the fight.
The Supreme Court in Reyes made it unmistakably clear that to prove implied malice, the act itself must involve a high degree of probability, not possibility, probability, that it will result in death. That's not a risk, Your Honor. That's not a possibility. That's not dangerous in some generalized way. We can have possibilities and danger that still do not reach the level of implied malice. It must be a high probability of death, not just a probability. And that means significantly more likely than not. I tried as I was preparing my arguments today to put this in terms that ring true to we lawyers and the community members at large as well. A high probability of death means it is significantly more likely than not just 51%, not just more likely than not just the famous scale to infinity, significantly more likely than not.
And I'm happy he's doing this because these analogies really help. TA said, if you're choosing to speed, couldn't you equate that to Papa Tragos' analogy of firing a bucket into a crowd? He may not have meant to hurt anyone, but he still had to know it was a possibility. And that's exactly what Jackson's explaining here. It's not a possibility. right? It has to be significantly likely that something's going to happen, that somebody's going to get hurt, right? I'll back it up so we can hear exactly how we explained it again. But think about every time somebody's ever sped. Now you can say 100 miles an hour versus, 50 and a 40 is different. And sure, we can talk about that. But speeding alone cannot possibly be enough to prove that somebody had malice in this way. And I don't think the state is purely relying on speed, but that's where Jackson is focusing. Just Call Me Kim said, wasn't he on his phone too? I know those are part of the allegations, but how legitimate is that? How reliable is that? How much did the state rely on that versus speeding? Is that why they said he lost control of his vehicle or admitted not having control of his vehicle? A lot of that is still to be determined, but they're definitely focusing more on the speed than being on his phone, which I think the defense says it's a road rage driver. The prosecution says it's a witness that warned him. I think he said he was looking in his lap or something, not necessarily that he saw him right on his phone.
That you're going to kill someone when you commit that act. That you're going to kill someone.
I'm going to back it up just because the question asked, like, how he gave this analogy.
That means it is significantly more likely than not just 51%, not just more likely than not just the famous scale to a feather.
Not just a possibility, right? Significantly more likely than not.
Significantly more likely than not. That you're going to kill someone when you commit that act. That you're going to kill someone when you commit the act. They rely on speeding. That's it. That's their entire theory. I've provided the court with 2 copies of the CalPERM. I just want to make sure that we're absolutely crystal clear about the language difference between those, the old and the new. They're marked. One copy is the CalPERM that people actually relied on. It was superseded and is no longer law. And one copy is the instruction post-Reyes, and that is the current law. In the old version, the objective standard, what I might have been arguing 10 years ago, before Reyes, highlights that, quote, implied malice requires an intentional act. The natural and probable consequences of the act were dangerous to human life. So be it. That's what the law used to be.
That's the old law, the natural and probable consequences of the act. That's the old law.
But the correct law regarding the objective standard now reads as follows. The defendant has implied malice if he intentionally committed an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would, not may, it would result in death.
Which is why you can tell there's a lot of room for judicial discretion here and even prosecutorial discretion, right? A lawyer can take the stand here, or take the podium, go up and make this argument, and they can sound really, really good, but it's not as black and white maybe as it may seem. And that's what he's trying to make the judge see, that it's black and white, see how this is not what this is made for based on these actions and these allegations.
The clearest language used by any court since Watson, defining a high degree of probability of death relating to traffic homicides, is the Moore case. The court explained in that case that Mr. Moore, the defendant in that case, drove 70 miles per hour on a neighborhood surface street, intentionally crossed into oncoming opposing traffic, causing other drivers to avoid him, intentionally ran through a red light at speed, struck a car in the intersection at speed without even attempting to apply his brakes, killed a passenger, and then evaded the police following that. And he did all of this, as he admitted, because of what he called, quote, wacky tobacco, end quote. That's a quote right out of the case, reasonably implying that he was high on marijuana at the time. The court in that case defined a high probability of death, and this is important, as a near certainty. A near certainty.
High probability of death is a near certainty. It's a big deal. Nina said, I thought the 103 mile an hour was in dispute. That speed would be crazy, almost impossible, but it doesn't sound like Jackson is fighting that speed. So it's a good point, a good question, a good thing to highlight. Every argument a lawyer makes is within proper context. And what he's trying to do here to get these charges dismissed, the M charges dismissed, is to argue even if the allegations the state made was true, like 103 miles an hour, it still fails. It's still the wrong charge. It still needs to be a lesser charge. So he's not going to argue that 103 miles per hour right now. He may argue it to a jury later. He may argue it to a judge later in a different hearing. But that's not going to serve the purpose in this hearing right now. The Burn said, off topic, but I was wondering if you got my email about the members only live giveaway on Halloween. I know you guys get a lot of emails. I'm not sure. I'd have to ask John about that. If you can put what the context of it was, we will have to check it out and see.
The act would result in death. That's what.
By the way, like I've already said, I haven't seen every single argument made. So even if he does argue the 104-mile-an-hour speed right now, it's not going to have an effect on the judge's decision, because the judge is going to assume he was going 104 miles an hour because that's what the state alleged. And if the state can prove that, then is it appropriate to have this M charge on top? So it would, even if he does argue it, it's not going to be something that's dispositive on how the judge determines today.
High probability of death means in California, not that the act possibly could cause death, not that the act probably would cause death, not that the act was dangerous or even highly dangerous, but rather that it's a near certainty that the act alone would cause death. Did the people say or establish in any way at the preliminary hearing that the mere act of speeding on PCH, that's what their postulate is, the mere act of speeding on PCH is nearly certain to cause death? That is absurd. They did not, because they cannot. It is objectively not true that speeding on PCH nearly always causes death. In fact, it does not.
And that's where the dangerousness of the road is going to come in, right? That the state can argue. It's not just speeding, judge. He was speeding on that road and he grew up here. He knows how dangerous that road is. That's why it's significant. That's why it's highly probable that somebody would get hurt. Because you're seeing Alan Jackson is using these words and saying, like, it's impossible, we've got to throw it out. Well, the state can say, no, it's not, judge. That's exactly what we intend to argue. We intend to argue just that the combination of all of these shows implied malice. Melly and Ali, thank you for the super stickers.
And the people well know it. So that objective factor, and the act claimed by the people as a high probability of causing death, has simply not been met. It wasn't met at the preliminary hearing. Therefore, there is no implied malice to prove this case, or to prove those charges. That is the controlling law in California, and it's simply not the standard that the prosecution applied, and it's not the standard that the magistrate applied, respectively. The prosecution argued at the preliminary hearing what the magistrate ultimately accepted is the old formulation, that an act is sufficient.
And then that also will make a difference too. Like, are they applying the correct law? What was applied at the preliminary hearing? Was it correctly applied at the preliminary hearing or not?
To satisfy the objective requirement, it is dangerous to speed. And again, if we were standing here arguing this in 2015 or in 2022 before Reyes, I might not even be making this argument. But here we are in 2025, post Reyes, and that's no longer the law. Danger is no longer enough. The Supreme Court expressly rejected that diluted standard and replaced it with a far, far more narrow standard. And that matters in this case. This is that type of case where the law actually makes a difference. The law actually defines what this court can and should do. Because failing the objective prong just ends the inquiry. We're just done. If the act does not objectively involve a high probability of death, there is no implied malice, even if the defendant was fully aware of the risk. And in this case, he wasn't, which I'll get to in just a second. The Supreme Court Justice that I referred to earlier, Justice Evans, has already anticipated and warned against the exact mistake that the people are making in this case. She literally saw it coming, the exact arguments that they're making, and warned the lower courts against that argument. In a published statement following Reyes, Supreme Court Justice Evans explained that lower courts in vehicular cases have been ignoring the objective standard, applying an outdated Calcrim language, and treating speed as if it were inherently sufficient to show implied malice. It doesn't get much.
So what he's saying there, that's interesting to me, that if they were to go to trial and lose, they might have a pretty good appellate argument. They might have a pretty good appellate argument if the higher courts are already saying the lower courts are not applying this appropriately. We made the change to get rid of cases exactly like this.
Clearer than that. She stated plainly, quote, and this is her quote, not mine, quote, speeding, even at a high rate, does not automatically equate to a high probability of death, end quote. That is not my characterization. That is a sitting California Supreme Court Justice explaining that in vehicular cases, you must apply the Reyes standard, and failing to do so is reversible error. The fact is, the people in their entire opposition relied on and stated the wrong law, and the magistrate got the law wrong as well. Justice Evans explained why that outdated law was changed. Why was it changed in the first place? Why even address it? She explained that thousands of Californians drive at excessive speeds every day without causing death. As the Justice noted, just as drunk driving does not always, or even usually, result in death, even as speeding That means speeding, even extreme speeding, cannot be treated as malice per se, which is what the
It's like, I don't love when you start going down that argument. Most people are not going to agree with you, number one, especially when you bring in the drunk driving part. Like that to me is about as reasonable to lead to death as anything else on the road. But the speeding argument, I think, is a good argument. It's like people speed every single day and they're not hitting people and killing people every single day. It's dangerous. You shouldn't do it. It's breaking the law. It should be a criminal punishment should be attached to that. If you speed and you hit somebody and you hurt them or you end their life, there should absolutely be a criminal punishment attached to that, but not this crime. And for the public watching, for lay people watching, for non-lawyers, non-judges watching this, I do think it's a harder argument to grasp and get around because we hate when we think about people texting and driving or speeding or running red lights or, God forbid, drinking and driving, right? We all hate that so much. But when you're making the legal argument and you're citing what higher court judges are saying, then to me, I think it's a pretty good argument.
People are asking this court to do what they asked the magistrate to do. There must be evidence that the act in the circumstances, the actual act in the circumstances presented, had a high probability of actually causing death. And here there is none. Not one witness, not one expert, not one data point, not a study, no, not one foundation of evidence that driving at X speed for X number of seconds has a high probability of killing someone. But people didn't even try to make that showing because they cannot. They relied instead on outdated pre-race jury instruction, and the Supreme Court's already said that's manifest error. And as Justice Evans said, I just indicated, she warned courts, don't do this, do not do this. And people are asking this court to do exactly that. If this court applies the law as it currently exists, as I've discussed it, post-Reyes, the murder counts have to be dismissed. Now we have the correct legal frame. I want to return back to the prosecution's theory. The one they propounded at the preliminary hearing, the one that they relied on in their opposition papers. At the preliminary hearing, the prosecution's argument was, there has to be a number where speed becomes murder. There has to be a number where speed becomes murder. It's undefined. There just has to be one.
And that's funny. So he made that argument, and somebody earlier said, who was it? I saw people kind of arguing about the speed, and somebody said, if it's 104, then I think here we go. Nina said, if it's really 104, then that's malice. So Nina kind of agrees with the prosecution's argument here that there is a number in which you say that's malice.
Where speed becomes murder. That was their theory then. They told the magistrate that speed itself was both the objective and the subjective proof of implied malice, and even in their reply papers, they do the same thing today. Objective and subjective determination of the lethality of speed. They're still continuing to make the same legal error. That's not the law. There is no magic number at which speed automatically becomes murder. The law doesn't permit implied malice to be inferred from some undefined mileage per hour or even a defined mileage per hour. And the Supreme Court in Reyes and after Reyes has...
Kelsey, will you do a poll that says, do you think Fraser Bohm is, and then the two options being overcharged or properly charged in consideration with these M charges we're talking about here?
Explicitly warn courts not to collapse those two objective and subjective standards or prongs into one single fact, like, for instance, speed. In the opposition, the people have abandoned their original argument. They've tried to replace it with something even more legally deficient. The idea that Fraser's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard. Because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench. That is not proof of subjective malice. That is proof that the defendant is a human being who's seen the same public safety billboards that you and I have seen and the rest of us, everybody in the audience has seen and are familiar with. Think about it. If this court, Your Honor, were to uphold the people's improper theory, every time there's a vehicular fatality, pretty much every time, all the officer would need to do is say, have you heard that speed kills? And if the unsuspecting driver says yes, now they're facing murder charges. Implied malice requires the defendant to have actually appreciated the specific danger of his or her act at that time. Not a general awareness that speeding somewhere, sometime, somehow may be.
So with regards to the polls, assume that 104 miles an hour is correct, that the state is alleging.
Dangerous. The requirement is this. I know the act is nearly certain to kill someone, and I'm going to do it anyway. That's the standard. as set out by the Supreme Court. I know the act I'm about to engage in is nearly certain to kill someone. Let me do it anyway. That's implied malice. That's the subjective factor. Nothing in the record comes close to that standard, Your Honor, and the people know that, which is why they're trying to replace evidence with inference and slogans like speed kills. The people also want to rest on the fact that Fraser knew friends who died in an automobile accident at some point in his past. They want to suggest that that's enough for his subjective intent to consciously disregard the near certainty that speed can kill someone. Your Honor, we all likely know someone tragically who has passed in some sort of traffic accident. I'll bet if I asked for a showing of hands in this courtroom, very few wouldn't go up if I said, do you know someone or know someone who knew someone who tragically passed in a traffic accident? But under the law, that's not the same as being sensitized to the consequences of certain acts. That's what the law requires. We have yet to find any case in all our research in which that was the predicate for the subjective requirement. And yet every case that we have found, including Ortiz, which we cited, states the opposite. The subjective requirement can be established only from suffering serious consequences from the government because of your own conduct. That's Watson. This court knows that case inside and out. That's Watson. The defendant has suffered sanctions by the government, warnings by the government in judicial proceedings, in a judicial governmental environment, that warned him against the very act he then went out and did again. That is missing here. The people cannot replace Fraser's subjective knowledge with a traffic slogan and somebody else's traffic collision. That's not the law. The court has never done it, and I seriously doubt that this court wants to be a first.
And yeah, those are little nuggets you drop. Like, you really want to be the only court doing things like this, Judge? Michelle said, I can see it both ways. Well, I'm going to talk about how that works at the end once we get the judge's decision. If you can see it both ways, what are you supposed to do as a judge? I mean, you can't really see this one completely both ways as far as the law is applied. Either it is old law or it is new law, but it's like once you figure out which law applies, which obviously he's going to say the correct, proper, up-to-date law, how do you apply these facts to that law and the arguments made by the state?
Thus, the prosecution cannot satisfy the subjective component either of murder or implied malice. There's no evidence, none, that Fraser Bohm believed he was actually traveling at 100 miles an hour, 90 miles an hour, 80 miles an hour. There's no evidence of that in the record whatsoever. The unrefuted evidence of what was subjectively in Fraser's mind is, the court read the transcript, I don't know, I don't know, I don't know, when asked over and over and over, how fast were you going? He said, I don't know. If Fraser did not know his speed, then clearly he could not have consciously disregarded a danger he didn't perceive. The Supreme Court has repeatedly said, you can't disregard a fact you don't know. Further, unlike in the Moore case, which I cited to the court a little bit earlier, and Gonzalez, which is in our papers, where the defendants admitted that they knew that what they were doing had a high probability of death, and they didn't care. They knew exactly what they were doing in both of those cases. The defendants in both of those cases said, I don't care. There's no evidence that Fraser knew what he was doing was, quote, nearly certain, end quote, to kill anyone, a high probability of death.
Nobody wears a sign around their neck saying, my intent is to do this. My knowledge.
The judge is like, well, nobody wears a sign around their neck saying, my intent is to do this. So you can make this argument in every case, Mr. Jackson. That's what he's saying here. Mo said, but was he speeding or fleeing road rage incident? Wouldn't the person who was chasing him also be charged with attempted M by the speed logic? They could be charged with a lot of things if they could actually prove that. But again, that's not going to be an argument they make to the judge right now, that he was fleeing a road rage incident. That's a factual question. That's going to go to the jury. This is a legal question to the judge, where even if these facts are true, Judge, this charge should not stand. It's a legal argument. The judge is going to have to step in and make a decision. It's not a factual argument like, how fast was he actually going? Was it a road rage incident? Was somebody scaring him? Was he fleeing? Those are arguments that will later be made to a jury.
Is so-and-so. It has to be judged by their actions and by the totality of the circumstances, doesn't it? Nobody comes out and says, my intention is to kill somebody when they point a gun at someone. My intention is to kill you. Nobody says that. You have to base your judgment as to what their intent was and their knowledge on their actions and on the circumstances surrounding it, don't you?
Circumstantial evidence has to be used to a certain degree. Absolutely, I agree with that. Nobody wears the sign around their neck saying, I intend to do this. But in every case in which that subjective knowledge has been imputed to a defendant, in every case, Ortiz, Gonzalez, Moore, all those cases have evidence in the record that the defendant knew what he was doing had a high probability of death and then ignored it. intentionally ignored them through his statement.
And so the state is going to argue something like, I assume, that he's driving on Dead Man's Curve, which he knows is dangerous. He chooses to speed for whatever reason. He knows that him speeding could have a significant high probability of hurting somebody, and he decides to do it anyways. And that's obvious because of the decisions that he made and the actions that he took without a sign around his neck. So that's what they're going to argue. That sure, we can take it step by step like Alan Jackson is trying to argue here, and we can still get to the charges we brought. Michelle said, since malice is inherently subjective, would that be a better call for the jury to make? I didn't watch the end to see the ruling. So eventually they will have to make it. But what Jackson is saying is, even with the facts they're arguing, the courts have already looked and said speed cannot prove malice, and all they have is speed. So it's kind of a hybrid question. Is it a little factual? Is it a little legal? He's saying legally they're saying speed is insufficient, and that's all they've brought. Therefore, it's insufficient for these charges. Just Rest or Reset said, can AJ argue Henry Ruggs 155 miles an hour, 3 to 10 year sentence? Listen, we all lawyers and judges know that speeding with collisions, even with fatalities, depending on where they are and the circumstances and context around them, can have a wide range of punishments, sentences, charges. And so you can use analogies. Jackson's going to use an extreme one, and I think he chose an extreme one on purpose to just try to show the judge and the world watching, like, this is crazy that we're here right now. And because the parallels of 4 young college students died in this case and the case he's going to use as an analogy, that's probably why he chose that analogy. But I bet he could find 100 situations where people were not charged with M or sentenced to life for something very, very similar to what Fraser Bohm is accused of doing. Lost 2 brothers and pregnant sister-in-law in traffic accidents in different times. Ms. Vicky, I'm so sorry to hear that. There's no doubt about it. So many lives are lost on the streets every single day from people doing stupid things, negligent things, intentional things, or recklessly disregarding the safety of others. There's no doubt about that. The question before this judge is, based on the facts here, is it enough for them to go forward on these charges?
Through his conduct after the fact, through fleeing after the fact, trying to avoid prosecution after the fact, saying, I knew I was going to go through the intersection, and more, for God's sake, the man drove through an intersection, killed a pedestrian, drove home, then said, when the officer said, well, you know what you did, didn't you? And he said, yeah, I think I cut the guy in half. It was disgusting. And there was subsequent post-conduct comments by all of those defendants to suggest they knew what they were doing and didn't care about it.
And those are all really good analogies to make in the case law of distinguish them from this case. What is different about those cases than the Fraser Bohm case? That's exactly what Alan Jackson is doing here. I think he's doing a good job distinguishing those cases and saying all of those reach that level because of the additional facts and context of those cases that we just do not have here, Judge. It wasn't only speed there. It's only speed here.
That's the inferential evidence that was used in those cases, and that's what I'm highlighting to the court that we don't have with Fraser. He didn't know how fast he was going. He did not have that information.
That post-accident conduct that's discussing it was a factor, but it wasn't in and of itself determinative.
It was a factor that they used in addition to the other factors to indicate inferentially that they knew that their conduct, that speeding on surface streets, high rate of speed, going through an intersection, etc., was inherently dangerous to a point that it was in that, as the jury instruction says, in that there was a high probability of causing death. That's what.
Also, I would argue, just logically speaking, I do not think you can be going 104 miles an hour. So if that's the number we're working with these arguments, and not know that you're speeding, right? So is there a magic number? Is there not? You can easily be going 5 over the speed limit, maybe 10 over the speed limit. But if anybody's ever been in a car going 100 miles an hour, you know it's going 100 miles an hour. You know it's going fast. Somebody doesn't have to tell you. You don't have to look down at the speedometer to know that you're going fast. Thank you, Chrissy.
Missing, Your Honor. The court is exactly right in highlighting this. Of course, no one's going to wear a sign or send a voicemail saying, I know what I'm about to do is nearly certain to cause death. The problem with the prosecution's case and the magistrate's holding order is that there's no evidence. The record is completely deplete of evidence that Fraser knew how fast he was going. That's why I brought up his statement.
How would somebody driving 100 miles an hour, 90, whatever the speed actually was up in that range, not know that you're going super fast? How would you not know?
Very good. So the judge feels the same way. Like I said, I haven't watched all of this, so I didn't know the judge was going there. But it's like at a certain point when your cheeks start shaking, right? It's like, I get it. I get it. People are disagreeing with me. Okay. I have done it multiple times in multiple different cars, new and old, smooth and not smooth. And I can feel it every single time. Okay. We can agree to disagree on that. Michelle thinks the new law is on AJ's side. I definitely think the new law is on his side, but applying these facts to the new law doesn't mean the judge has to dismiss the M charges.
Super fast is not the standard.
No. But answer my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not.
The judge is like, I get, we're just doing one thing at a time. Let's take little pieces. And even Alan Jackson agrees. Okay. So everybody that's disagreeing, even Alan Jackson agrees that at a certain point, you know, you're going really, really fast.
It's not enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know.
And guess what? It doesn't matter what you think in the chat. It doesn't matter what I think. If the judge thinks that and he's the one making the decision, that's important. And the judge is saying logically at 95 or 100 or 105 miles an hour, you know you're going fast. And yes, I understand the defense is disputing that. They think it's a lot less than 100. The state think it's over 100. But at this point in the argument, the judge is looking at it like, if he's going 100, do you know you're going 100? Is that enough to say that you're going to recklessly disregard the significant chance somebody's going to get hurt and you still do it anyways and then somebody gets hurt? And how do I deal with it if those are the facts right now at this phase, right? Which is not the trial phase. It's not proving the case beyond a reasonable doubt. It's not before a jury. We're not going to settle all factual disputes right now.
If other cars are driving 70, 75, 80 on the Pacific Coast Highway, which, Your Honor, they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was either going the same speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles an hour, whatever the speed is, which the prosecution cannot find in a 25 mile an hour zone right next to a school. He's on PCH. And other cars are going similar speeds. Yes, he may have been going faster than the cars next to him, but not to a degree that it's a near certainty to cause death.
And that's the good argument from Alan Jackson. He's like, even with that common sense argument, Judge, if all the cars are driving the same, even though you're going fast, as far as perception goes, you don't think it's dangerous. So even if you're driving fast, it doesn't automatically mean it's dangerous, right? Now I know the PCH is a dangerous road, and there's going to be arguments both ways, right? That's what makes this fun. Is it's like Jackson's responding, the judge is asking questions. We're going to hear from the state, I assume, at some point, but we're only like a third of the way through this. Oh boy, and we're already 40 minutes in. All right, buckle up. We're gonna have to get through the rest of this hearing to see what the judge says at the end.
That's the point which it would have to be.
I want to discuss the testimony to Freeland and what the underlying facts of the case are, but just as a review, all of the evidence from the civilian witnesses in the case is that the defendant zoomed away far faster. They couldn't even come close to saying whether he was driving so fast. He was hundreds of yards ahead at the time of the
witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70. That was in the preliminary hearing transcript. I went there. That's what they said. That is not extraordinary, and certainly that's not enough to suggest a near certainty that someone is going to die. It's just not enough.
That's interesting. The 104 miles an hour, he's saying even the state's own witnesses don't necessarily agree with that at the preliminary hearing. Okay. So now we're talking maybe it was only 70. See, but I think once you start to get into factual disputes like that, the judge is less and less likely to really make a big decision. That's just my opinion. That when you're really starting to argue the facts, the judge is like, whoa, I'm not the finder of fact here.
I'm not saying, and I don't want to get spun into a discussion or even an argument with the court about was it dangerous. We can all agree speeding is dangerous. We can all agree that it has a possibility of causing death or great bodily injury. We can all agree with that.
That's exactly it. This is like turning out perfectly. It's almost like I planned this. But yeah, he does the right thing. He's like, let's bring it back to, even if all this is true, right? We know it's dangerous. Speeding is dangerous. Even if all that's true, let's get to what my argument is to why you still need to dismiss these charges. I love it.
It has a possibility of causing death or great bodily injury. We can all agree with that. That's not the law.
Can we agree that the faster you're going, the more likely it is to cause death?
Depends on how fast you're going. Absolutely depends on how fast you're going. We can all agree on this. According to Justice Evans, that's not enough. Right. That is not enough by itself. And that's the only thing the prosecution has.
Judge said right after he said, that's not enough. And so the judge keeps asking like factual questions. And Jackson is doing a good job that even though he's answering the factual questions, he's saying, even so, the justice says that is not enough. Michelle said, I think it's for the jury to decide the charges stay. Okay, we'll see if the judge ends up agreeing. Ocean Beach said, can you show Chad a video of Dead Man's Curve? Are there lesser charges? If not, couldn't the jury acquit if they don't find M? There will be lesser charges, in my opinion. By the way, about 70% of you think that he is overcharged, and about 30% of you think he is charged correctly. So that's interesting. We'll see if the judge agrees. I'm not going to show a video during this video just because we don't have enough time. But if you guys can all hit the like button, and if you're interested in this case and following this case and digging deeper into this case, maybe on a future video, we will play a little video of Dead Man's Curve. I think it's a bit prejudicial against FB as Dead Man's Curve is Sunset Boulevard, not PCH. Okay, interesting.
Speeding. That's it. And that's notable. The people routinely charge vehicular manslaughter, not murder, just as the court is discussing.
And that's really what Alan Jackson wants, is this vehicular manslaughter, not these charges. And yes, that's basically what the outcome, that's what Jackson wants the outcome of this hearing to be.
In fatal speeding cases, unless there's clear evidence of the subjective knowledge. 2 weeks ago, to the court, 2 weeks ago, maybe not 2 weeks ago today, maybe it's 14 days, 15 days, 13 days ago. It was October 25th. This same office filed manslaughter charges in a case called People versus Kirksey. The driver.
So that's a good analogy to make, right? You don't just pick random analogies. You don't just pick Henry Ruggs. You don't just pick famous people. You look at this office right here and the charges they brought under certain factual scenarios. And if you can differentiate them with your client, to me, that's the best argument if I'm the judge to be like, come on, guys, what are you doing? Let's hear what he has to say. I don't even know what he's going to argue here with this case, but I like the analogy already.
Speeding on surface streets, drove onto the sidewalk, struck and killed 2 pedestrians, severely injured 2 others, then fled the scene, then fled the jurisdiction. He was finally caught in Chicago 2 weeks ago. Killed 2 pedestrians, injured 2 others, fled the jurisdiction, and fled for the specific purpose of avoiding prosecution. Manslaughter. They didn't even approach murder charges in that case. If the law is...
So it's like even worse than Fraser Bohm as far as after the fact, right? Now, what was he doing before? How fast was that driver going? Where was he going that fast? Was it truly that he lost control? Was it raining that day? Was there a malfunction in his car? There's all sorts of context we don't necessarily know, but I love that analogy because now if you're making that argument to the judge, it's like even these people over here, these prosecutors don't agree with what they did in this case. Come on. I like that analogy.
Anything. It's got to be deliberate. Fraser, by contrast, as established in the facts of the preliminary hearing, stayed at the scene, cooperated with investigators, no drugs, no alcohol on board, no driving history, no fleeing, no secondary criminal act, all of which this other case had. Like I said, the law is anything, it has to be deliberated, it has to be consistent. And that means that similar facts should produce similar charges. And less aggravated facts should never be charged more severely. Selective charging is not just unfair, Judge, this court knows, it's unconstitutional. Here, there's not even evidence that Fraser intended to drive fast for its own sake. Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by an individual seconds before impact. That is not malice. I'm not arguing that it wasn't dangerous. That's not the law. The law is for malice. It has to be a near certainty to cause death, and he has to subjectively say, I know it, and I don't care. That's their burden. What we have before us is instinct. Not intent, not subjective intent. This was not malice. This was an accident. Perhaps negligence, not murder. The people now argue in their papers that the cause of the crash, astonishingly, is irrelevant. That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant. Your Honor, this is a murder case. Causation is everything. If Fraser was clipped or swerved or reacted to external events, then his act was not the probable cause of death. That alone defeats the murder charge. And the people's own exhibits show driver's side contact with his car, white paint transfer, matching the damage to Ms. Ortiz's vehicle. The very facts that the prosecution sort of wants to pretend doesn't exist. And you cannot argue implied malice when the defendant's conduct was reactive rather than intentional. Your Honor, Section 995 exists for exactly this reason, to purge charges that sound great or based on legally unsupported theories. The Supreme Court has repeatedly instructed that 995 motions must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law And the governing elements were misapplied, and that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted that there must be a number, there must be a speed.
It's funny. Multiple people in the chat, some are like, I can't stand Jackson, but I agree with him here. Other people are like, I love Jackson, I'm just not with him here. That you guys are doing well. Just look at every situation as fair and unbiased as you can, regardless of what you think about Jackson, Bohm, anybody else. You're looking at it and you're trying to decide what do you think is right. And even you two are disagreeing, and that's fine. I think that's kind of the issue here, and the outcome is going to illustrate that.
And that's legal error. The people continue to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close. It's not debatable. It's mandatory. If Reyes governs, and
he's saying the judge doesn't even have discretion here. I disagree with that, but he's saying the judge has to throw this out. T said, "Why do we treat killing people with a car as a lesser crime than killing with some other way? It's still M." So I would completely disagree. Whether it's a firearm, whether it's a knife, whether it's a car, intent is what matters. You can have accidental killings with all sorts of weapons, including a car. Or you can have an intentional killing, which would be an M, with a car. I agree with you. Just because it's a car doesn't mean it's automatically not an M. But intent matters. People's actions matter. How the person passed matters into what you're going to charge them with.
Reyes does. I think we're all in agreement, including the court, that Reyes now governs. If the current California 520, which I placed on the court's bench, governs, I think, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and I'll close my closing comments are these. There's one unavoidable question. Did the prosecution present evidence that Fraser Bohm committed an act involving a high probability of death at the time, that he knew it, and that he intentionally disregarded it? The answer is no. Not a little bit, not barely, not depending on how you look at it. The answer is just no. No intoxication, no racing, no tests, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever. And no objective showing of a high probability of death to a near certainty. Just speed. And speed is not malice. Section 995 is that safety valve, the safety valve that every member of the community relies on. It prevents exactly this kind of overreach. And a law demands that the murder counts be dismissed so that this case can proceed on the proper charges. The charges the evidence actually supports. Manslaughter, not murder.
Yeah, it would be an easier case to prosecute Bird if it was just manslaughter, but you have a lot more leverage with these M charges. So that could be one of the reasons why. And Michelle, this could be the slogan of this channel. I like you, Peter, and sometimes I disagree with you. That's how it should be around here. Okay, that's how it should be around. If you hate me, I don't know why you're watching. And if you always agree with me, that's a problem. You gotta disagree once in a while. We're probably not going to see everything eye to eye, even if it's small details. It's good for critical thinking.
We ask the court to dismiss counts 1 through 4.
They just asked a question if the people presented that at preliminary hearing. Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15.
He's like, we've already asked this question, and the judge said he acted within reason for something causing a high probability of death or having a high probability of causing death. So yes, he looked at the circumstances, the magistrate, the prior judge, the preliminary hearing, and agreed with that.
The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understand, he was applying the very law the counsel's been saying.
He's like, so we argued all the facts of what Fraser Bohm did, and did it rise to that level? And they said, yes. What are we doing here?
I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce, they confirm that there has not been a fundamental change to the law. They say, quote, finally, we note that the defense contends the high court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life as requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new And Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce case, no, because it's stating that this already exists, that this is not new. This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the act were dangerous to human life.
That's not the same. That's not as stringent as a requirement.
It is different language, but the point was that that was the language that was provided to the case of jury. And the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order of holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination.
So it sounds like the prosecutors at least somewhat agree that speed alone is not sufficient. So what are you going to add to the speed alone argument?
Watson and all of its progeny, again and again, they don't provide any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant is driving down an open road with no other vehicles, with no other cars.
The context of where he is, what he knows about, being on Dead Man's Curve, PCH, whatever you want to call it, when compared to some of the other cases, again, the one that Alan Jackson just mentioned where the guy jumped the curb and killed 2 people and then fled. Maybe that was on an open road. I don't know. But he's saying if you're going 100 miles an hour on an open road where there are no other cars there and it's totally desolate, that's very different than on PCH. And to me, I think that context does matter. And I think it does make a difference.
Pedestrians just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did. He also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because...
So that hurts Jackson's like, well, everybody's going fast, so maybe you don't know how fast you're going. It's like, well, if he's maneuvering around cars going slower...
And according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. Now, he claimed that that vehicle then started to merge into his lane. So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say. There is not evidence presented at preliminary hearing or anywhere else other than the defendant's statement that there was any contact between the defendant's vehicle and another. And the physical evidence shows that that did not.
Sweet Southern Honey and a bunch of people are asking, can anyone show proof of his speed? So right now it's just whatever was shown in the preliminary hearing, which I didn't watch. It sounds like it was testimony. I think they have black box data. I think they disagree with each other on the black box data. But again, the exact speed is not something that has to be proven here because one number, as they've already argued, is not the bright line rule. Like once you cross 100, now it's murder versus manslaughter if you're under 100.
I don't understand where
The mirror was
the mirror was.
out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's mirror was knocked forward, and that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle, and certainly being the fact that the other vehicle suffered no damage on its mirror. The important point then is that this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts to turn, he does not have sufficient time in order to control his vehicle And I did want to point out that the one thing that the defense didn't talk about was the fact that the defendant said when that vehicle came into his lane, he swerved to avoid it. We had the electronic data from the airbag system, and that was presented and put into evidence, and there was no swerving to what would be the light to the right. The only inputs were to the left. The only steering inputs at all were to the left, contrary to what the defendant said. And as I noted in my moving papers, and I won't go into great detail, but it does show that the defendant understood that what he was doing was dangerous, and he was coming up with excuses as to why the collision occurred.
And again, you can use circumstantial evidence and other people's testimony that he understood what he was doing. He continued to drive. No enforcement traffic that he's having to go around other cars. He knows that there are driveways going down the street, parallel parking, people walking. He knows all of that, chose to do it anyways. That's the argument the state's making. Ryder Kitty said, what kind of car was he driving? Does this matter? How many people does this matter to? If he was driving a red Corvette versus a minivan, but let's just say he's going 100 miles an hour. If he's going 100 miles an hour in a red Corvette, does that make him more guilty than if it's in a minivan? He was driving a BMW, but just interested in what people think about that.
The other important factor about the speed and the electronic data control is that at the outset of its reporting, which occurred 5 seconds prior to the first deployment of an airbag and some 7 seconds before the final deployment, those inputs included an engagement of the stability control system, meaning the vehicle was not stable in its movement. In fact, we heard testimony at the preliminary hearing from Miguel Cucino that he observed the defendant's vehicle skid, lose traction with the road as he saw it then speed off. He said he could see the puff of smoke. According to the electronic data, that occurred when the defendant was doing 93 miles an hour and had his accelerator at 79%. He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just...
So Goody said, there's just too much unknown for me to have an opinion. And when you get there, if you're a judge and you're looking at all these factual disputes, what do? You just basically say, with everything the state is saying, can they possibly prove murder in this case? And if the answer is yes, then you let it stand.
He's going faster and doesn't notice it, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above.
Again, some of this seems like argument. I can't really tell where the factual basis for some of this is. If this is what came out in the preliminary hearing, the judge should know that, even though we don't. So just saying this doesn't mean it's already something that you've put in as fact. So that'll be interesting.
Of the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known? In regards to...
Again, that's kind of like the logical argument. How could he not have known?
The defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of the speeding. It was the defendant himself in the statement who turned the slogan into something personal to him, that he had 2 of his best friends die as a result of speed. The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was 130 miles an hour, caused the death of his 2 best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, or and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice New, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality.
So doing like good lawyers do, right? Alan Jackson makes it seem like the burden is incredibly high, a significant possibility. And the prosecutor argues that the burden is really low. It's not a certainty. You don't have to know it beyond a reasonable doubt. We're not there yet.
Of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted there, this isn't just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. If he knows it like the back of his hand, he knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the cross.
So they're using his own statements against him, right? Which again, no surprise there. But he knew he knew it like the back of his hand. He knew speed kills people. It killed some of his friends. So they're thinking about his mens rea, right? His mindset. He knew this was dangerous. He knew speeding is dangerous. He knew what people are doing on the road, walking around the road. All that context, he decided to disregard and speed going 100 miles an hour, 200% or whatever of the speed limit, knowing that it could lead to death, and decided to do it anyways, disregarded it. So they're trying to add more context because they've agreed with Alan Jackson that speed is not enough.
Swap that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this, and yet with that knowledge, with the knowledge that he is already losing control of his vehicle due to speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, there has been an abundance of evidence, that more so than is needed. But the point is, at this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Very briefly, first of all,
And then also relying on the fact that you've already won is always a smart move. All right, we're going into the overtime here. We're at the hour mark-ish of the video. We still have about 30 minutes left of the hearing, especially we want to hear what the judge has to say. So make sure you guys hit that like button if you haven't. Make sure everybody is subscribed to our channel if you haven't already subscribed.
first thing I want to mention is the math is wrong. And exceed the speed limit by 230%. The math is wrong. If the speed limit was 45 or 50, 230% would be 145 miles an hour. That's absurd. 100% is double. 100% on top of that.
He's like, you're kind of stupid, prosecutor. No, not really. He didn't say that. But he's like, the math is wrong, so let me do the math for you. But again, I don't think those factual arguments, I don't think help Alan Jackson personally.
The 45 again. So let's get the math right. It wasn't. Was he speeding? Sure. But I don't want to get ridiculous about this. 230 times. I don't know what the hell was he doing? Jet. You got the math wrong. Let's talk about the facts. Provable facts. Mr. Bartos says he was speeding. Okay, that's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that. There are homes at the side of PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous. There are trash cans. People have to put their trash cans out. That's dangerous. There's no sidewalks, and yet there's still pedestrians crossing the street. It's also dangerous. He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe, maybe not. And going at a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish a high probability of death? That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Well, this was dangerous, this seemed dangerous, this is dangerous, this is dangerous. That's not the law. As the court rightly termed, the jury instruction, it was changed for a reason. The Pierce case didn't stand for the proposition that it's all the same. It's always been a high probability of death. That's not true. The Reyes case changed the law. And the jury instruction was changed because of that, as the court noted. We are not talking about something that's dangerous. Is excessive speed dangerous? We go out on Van Nuys Boulevard, where the big boulevard is, Van Nuys Boulevard, outside the courthouse. How many folks are going to be speeding on that road? We can look for 10 minutes. How many folks are going to be speeding on that road? Nearly all of them. Nearly all of them. It's California, for God's sake. Fair enough, fair enough. I'm making the point, but I don't mean to upset the community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
circumstances would, in your
And I do think that this is just such an interesting thought exercise for us, which is why I wanted to watch it and listen to it together and get your guys' takes. And I've been really loving reading the comments on this, and people are kind of all over the board on it. Whether or not the judge dismisses these charges, it is going to be very, 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 very difficult for Fraser Bohm to walk out of this unscathed, I think. Because when you hear the details and you hear the facts, I think a jury is going to be angry at him, which is why I think this is very important work Jackson is doing on the front end to try and get rid of the highest charge, because it's going to be very difficult dealing with the lower charges, if that is what the case ends up being at trial.
Represent a driving that presents a high probability of death.
If he was high, but
whether you're high, you're drunk, or whatever it might be.
The judge is like, so then how do we ever get there? How is it ever speeding is a high probability of death? And Jackson's like, high, drunk.
if he was high,
But whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident. Who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or pedestrian and kill them?
let's say that there's
I definitely think it's a higher likelihood if you're drunk or high and speeding.
a circumstance in which
Isn't there a large degree of bad luck? Too?
luck is not enough. It has to be guessed. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists, Judge. That's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, they shouldn't be doing it, it costs somebody their life. In every manslaughter case, it's important to reflect. I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case, every one, someone died. By definition, someone lost their life. If what Mr. Bartos is saying is right, basically, well, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work. There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of our cars, and you never know that it's going off. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works.
Yeah, and we're getting into some factual arguments here that I don't necessarily think are going to help him. But you're also hearing on this case is going to have a lot of technicalities on it. Probably a lot of expert testimony on this stuff.
The question to answer the court's the answer to the court's question is, what would show a high probability of death? Street racing, 500 miles an hour on certain streets. High probability.
Street racing. Okay, so now you get into, it's really the thought process. And how do you prove the thought process of the defendant, the driver of the at-fault vehicle? So he's saying street racing would cause a high probability of death, not just driving fast with the traffic and weaving in and out on a dangerous road. This is what lawyers do, right? We differentiate circumstances. You better have an answer to this. I've seen lawyers in this scenario right here that Alan Jackson is in, where the judge wants an example of what would make your client eligible for this charge. You better have an answer, and that answer better not be the facts surrounding your client's case. And that's exactly what Jackson's doing here.
Why is that anymore?
Because
More likely
street
to
racing-
cause death than driving 100 miles?
Because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts surrounding pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian standing five.
Not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving it in a manner in which it was not designed to be driven. It's drifting, by definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic. Driving on a sidewalk, driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? I was sort of touched on an example I was going to raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road, where you're on a straightaway, there's no other cars, and nobody's around, and you can just go in 100 and not have to turn the wheel. There's a difference between that and driving on a dangerous guided road like PCH, isn't there?
They're both dangerous, but neither one of those by just driving fast alone. Neither one of those include a high probability of death. People.
And I think that his like street racing example or his drifting and doing circles are common examples that people understand the mindset of people that do things like that and trying to push your car. And he did a good job making the argument, but I do think it opens the door for some of the arguments the prosecutor made, which is he wasn't just speeding. He was speeding on a road that he knew was dangerous. He knew like the back of his hand. He was weaving around other cars going slower than him. So he knew he was speeding. He knew he was going fast. And he knew speeding kills because he talked about how it had taken the lives of people that he knew in the past. So they are creating additional context versus just somebody speeding. It's just not the same context that Jackson is creating with his street racing and drifting examples.
Do it every day, Judge. On PCH, they do it every day and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Fraser Bohm should be saddled with murder charges. These are the same charges that Brian Koberger is facing. That's the point. Brian Koberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood.
And again, while that's a great argument, okay, it's a great analogy to make. It would hit home with me like, what are we doing here? But legally, murder can look very different. So can manslaughter, so can assault, so can battery. It can look very, very different and still both be appropriate. But it's a good headline. It's, a pounding the table moment. I think it would work if it was for a jury. But for a judge, my guess is it's not going to have that profound of an effect. I also personally think it's a great decision or a great point because if I was a prosecutor looking at these cases, I wouldn't have to go to Idaho and look at Brian Koberger. I could look at my own office, right? He's using this because everybody watching knows what that is. There are examples right within that prosecutor's office that he could say, those heinous crimes that you guys charge as murder, that is what it's appropriate for, not Fraser Bohm, not this. Just look at the case you guys charge as manslaughter. That to me is just as good of an argument, but that's more of an argument to a prosecutor to me than a judge. That's more of an argument to a prosecutor. You want to reduce the charges or change the charges, not to the judge.
Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't murder. Thank you.
Thank you. Any response to that, Mr. Rogers?
Yeah, let me see. The evidence was sufficient for the magistrate, and he was correctly applying the facts to the correct law. And anything beyond that would be this court using its own decision-making, which is not it's simply...
Well, Kirk Counsel is aware, I'm just put on the record name that standard 4995 motion. According to the write-out.
All right, here is the judge's decision.
Which is Superior Court case 67, count second 471. Reasonable probable cause is shown if a man of ordinary caution or prudence would be led to believe and conscientiously entertain a strong suspicion of the guilt of the accused. That's the magistrate's job. And then Bella case 1983, 33, count 3rd, 754, reaffirms that the magistrate's finding of probable cause should stand supported by any rational interpretation of the evidence.
I'll just tell you, by the way he's reading it, he's really lowering that bar. Any rational interpretation of the evidence, the magistrate's ruling should stand. So when you're talking about how low that bar is, it's like, am I really going to overturn this, Jackson, what the magistrate allowed for these charges?
If there is some evidence supporting the magistrate's conclusion, the information may not be set aside. Some evidence. People versus Superior Court, Decker, 2007 case, California Supreme Court case. The reviewing court asks whether the evidence provides a rational basis for believing the defendant could be guilty of the charged crime. Every legitimate inference that may be drawn from the evidence must be drawn in favor of the information. The judge, in my position, is not to reweigh the evidence or judge the credibility of witnesses. At the 995, the question is whether there was simply probable cause to hold the defendant to answer, and that's all.
It's like the facts being argued for beyond a reasonable doubt guilty verdict is not what we're doing here. That's not how I'm looking at this. Are these closing arguments? It feels a little like that, doesn't it? And that's not usually a winning strategy if you're the defense attorney in this case. If he wasn't a rich kid with a fancy lawyer, do you think the charge would be the same? So he was charged with this before Alan Jackson was ever brought in. Maybe he had a fancy lawyer before. I'm not sure. I think this almost has more to do with the victims and the notoriety of the case, and the victims' families probably having some push to really get the highest, most serious charges possible, more than who the defendant is or who the defendant's lawyer is, if you want my honest opinion. Because I believe all of the victims have lawyers as well.
Discuss facts here, and then I will discuss the law. I'll apply to going through the board. There's no doubt that the man was driving extremely fast on PCH. All the witnesses described it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote.
And so this is how the judge is looking at the speed, not necessarily 104, not 70, but extremely fast, because that is the testimony from the preliminary hearing.
Flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bohm's car said he was doing close to or even above 100 miles per hour.
He's charged with murder, the same thing Brian Koberger is charged, 4 counts for the 4 victims.
In the instance before the crash in a 45 zone, the magistrate noted the data recorder evidence carried weight in his decision-making, acknowledging that while there are warnings that come with it that say it can make mistakes, there was no evidence presented at the preliminary hearing in this case that it made errors here. The defense said that Mr. Bohm was fleeing a road rage incident with Mr. Victor Calandra. There was no evidence of that in the record. The evidence in the record was that Mr. Calandra, when stopped next to the defendant, at a light a few moments before the crash, rolled down his window and warned the defendant he needed to be careful, yelling at him, "You need to be more careful, you're going to hurt yourself." Mr. Bohm did not respond. On cross-examination at the prelim, Mr. Calandra said he also included slow down. And he also said he might have said you're going to hurt yourself or someone. He said those things because he had seen the way the defendant was driving prior.
And if you believe that he said you're going to hurt yourself or someone, he's on notice, this is dangerous, and he decides to speed anyways. Again, that might not be how the facts come out of trial, but that's how the judge is looking at it here.
Stopping at that light. He testified that the man was driving erratically and drifting extensively and speeding. Why else would he say those things to Mr. Bohm? He hadn't seen him driving in such a dangerous manner. That does not sound like road rage to me. The defendant did not even react to Mr. Calandra. When the defendant took off from the light, he zoomed away from Mr. Calandra, and there's no evidence that Mr. Calandra accelerated in any attempt to keep up with him and chase him. The attempt to back this defense theory of the case with evidence of a prior incident that Mr. Calandra was involved in did not succeed at the prelim, as Mr. Calandra's testimony was that in that prior incident, the other driver pulled him out of the vehicle and attacked him. Maybe other evidence will be discovered or developed as to that incident as this case goes forward, or maybe not. But the testimony at the preliminary hearing in this case was Mr. Calandra's recounting of it, and that was all.
The way the judge is there looking at some of the facts doesn't seem like he's necessarily buying the road rage flight at this point, but it doesn't really matter if he buys it or not, because that's going to be a jury question.
Defense also argues there's evidence that his driver's side mirror was hit somehow during his incident by a white car. Mr. Calandra's truck was bright blue. And that I think the argument is intended to be the contact with a white car was somehow causal of this crash. There is evidence that the mirror was damaged. The Ortiz sisters were both driving white vehicles, but neither said they had any contact with the defendant's vehicle. And both said the defendant zoomed off from the light and was way, way, way ahead of them at the time of the crash. This would undermine any causality if there was contact between one of those white vehicles and Mr. Bohm's vehicle. Mr. Calandra also said the defendant was several hundred yards ahead of him at the time of the crash, and his speed was excessive, at one point saying 80, 85 miles an hour, and he did tell the detective it was maybe 70. Mr. I'm not mispronouncing it, Scrucchino said the defendant passed the white car, was going very fast, and was perhaps as much as 600 meters ahead at the time he swerved and then the crash happened. No matter who was more accurate, it's clear that the defendant was far, far ahead of all these other cars at the time he lost control of his vehicle, even if he had previously bumped into one of those cars and damaged his mirror, although there's really no evidence or no testimony that happened, other than the defendant's statement to deputies later. As far as the evidence of the defendant's statements go, the most salient ones for purposes of this motion are that he understands the meaning of the aphorism, speed kills, which he affirmed to deputies. But it wasn't just, yes, I know what that means, I saw it on a bus bench or the side of a bus, as you termed it, Mr. Jackson. He in particular knew what it meant because he said that his two best friends, as he described them, had been killed in a high-speed accident.
So he's basically using the defendant's own words against him and using the prosecutor's argument. So you can see where this is going, I assume.
And then he also said that he knows PCH, I'm quoting here, like the back of his hand, because he lives nearby and drives with PCH all the time. Well, if he knows the PCH that well, then he in particular would know how dangerous of what it is, how frequently accidents happen on it, and he would presumably know where a dead man's curve, where this accident happened, is. Those are the basic facts of the cases I gleaned from the preliminary hearing transcript. Turning to the law, I'll just state it. Murder is the unlawful killing of a human being with malice aforethought. Malice may be either expressed or implied.
The killing with malice aforethought. Okay, that is the difference between manslaughter and this higher charge of M.
Is expressed malice when the defendant manifests a deliberate intention to kill, which we do not have here. Malice is implied when the
He said you do not have to have the specific intention to kill, which is how most people define malice aforethought, but it can be implied malice aforethought. Again, something that is significantly likely to cause death or serious bodily harm, and you disregard that and you do it anyways. Therefore, you're basically wanting to cause significant bodily harm or death.
May be either expressed or implied. Is expressed malice when the defendant manifests a deliberate intention to kill, which we do not have here.
That's what he's saying. We do not have express malice. It's implied, is what they're arguing here.
Malice is implied when the circumstances attending the killing show an abandoned and malignant heart. Malice should be implied when the killing proximately resulted from an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that would result in death. That is the new formulation. At the time he acted, this is continuing with the definition of implied malice, the defendant knew his act was dangerous to human life and deliberately acted with conscious disregard for human life. Implied malice requires the defendant act with a wanton
Deliberately acted with disregard for human life.
disregard for the high probability of death, thereby requiring a subjective awareness of a high degree of risk of death. It is not enough that a reasonable person would have been aware of the risk. Malice, importantly here, may be inferred from the circumstances, all of the circumstances of the incident. Doctrine 520 defines implied malice has to be such that the natural and probable consequences of the act involve a high degree of probability that it would result in death, not merely.
So again, he's reading the law just as Jackson stated it. He's just not seeing it the way Jackson did. Mercury said, was there a break or had the judge already prepared this? My guess is the judge had already prepared this and knew how he was ruling, which is not a surprise because, again, they filed briefs, they wrote all this out already, and then they reiterate it in arguments.
Threat to or conscious disregard for the safety of others so that it would result in death. More than possibility or likelihood of death is required, the act itself must give rise to a high degree of probability that death would result. The defendant must personally harbor implied malice. I'm aware of the Carr, CARR case, which stated that a simple act of DUI is not enough for implied malice, and that the defendant's actions before, during, and after the DUI were also relevant to the determination of whether malice existed. While a dangerous act may be insufficient by itself to establish that the actor had subjective knowledge of the risk, it may be a relevant consideration in finding malice. Importantly, implied malice is to be based on the totality of the circumstances before, during, and after the act.
Implied malice is based on the totality of the circumstances. That's what the state was arguing.
The prosecution must have proof specific to this defendant that shows his subjective mental state at the time of the act, that he knew and appreciated.
They must have proof. And Jackson's like, they had no proof. Prosecutor said they did. Judge is siding with the prosecutor.
His actions were dangerous to human life, and he deliberately acted with conscious disregard for human life. The prosecution, quite right, Mr. Jackson, must prove both the objective danger that the conduct presents to life, as well as the defendant's particularized subjective awareness of the risk of death emanating from his conduct and his disregarding of it. I don't think anyone could seriously contend that, objectively speaking, driving 100 miles an hour on PCH, other cars on the road.
And so now he says driving 100 miles an hour, which in his mind, he's giving us a little tell there. He doesn't think it was 70 or 80 or just really fast. He thinks it was 100 miles an hour.
Pedestrians, homes, restaurants, parked cars, people walking their dogs, and the like. I don't think anyone could seriously contend that the natural and probable consequences of that conduct in that environment, in that place, at that time, do not involve a high probability of death. Of course they do.
course they do. So he's like, this ain't even close for me, is what it feels like. This ain't even close for me. I think that state did it right.
What's difficult about this, you sort of touched on this, Mr. Jackson, is it's very difficult to quantify the likelihood of death, because you're quite right. Sometimes people drive 100 and they don't have any accident at all. There's no way to know that because there's no accident, there's no reporting of it, and there's no statistics for it. So we're left to what we do have. The defense argument is that Mr. Bohm, knowing PCH like the back of his hand, as he said, cannot be said to have the subjective awareness that his speed would cause death, or highly probable would cause death. But if he knows the highway so well, it's reasonable to assume that he knows what a dangerous road is. How many accidents, including fatal ones, occur on it. He knows what and where the advanced curve is. This familiarity with the PCH does supply him with the subjective knowledge that his actions on it are dangerous to human life, and the subjective appreciation of the substantial risk of his actions on that road in that moment. The substantial risk of that occurring. That personal subjective awareness would have only been enhanced by Mr. Calandro's warning to him at the stoplight that he needed to slow down or he was going to hurt himself or hurt someone.
See? All the things we highlighted throughout, those are the important parts the judge is looking at for the context and how important it is. And basically, he's saying, kind of similar, Mr. Jackson, to how you described street racing or drifting, those circumstances existed here for Fraser Bohm. He knew because he knew the road was dangerous. There were people walking around. He chose to drive that fast. He was warned he was going to hurt himself or somebody else. He knew speed kills. So he's kind of creating that scenario where this really isn't any different than street racing or drifting, which you agree can rise to the level of being in this first-degree charge.
If he hurt Mr. Calandro, which is not clear. I have reviewed the cases cited by both counsel and their motions. None of them are exactly like it practically. Well, basically, we've nevertheless provide guidance, and I know counsel discussed these a little bit, but I will as well. In People versus Canizales, at 197, Cal. 4832. The court held that the evidence was sufficient to find that the, and this was a pre-phrased case, the court held that the evidence was sufficient to find that the defendant acted with conscious disregard for life, and therefore to convict them of second-degree murder. Rejecting the argument, there was no evidence that they were aware of the risk involved in their conduct. This is the case in which the defendants had modified their cars to engage in street races. They had consumed an unknown quantity of beer, raced side by side on a residential street, reaching speeds of up to 87 miles per hour, ran through a stop sign which they must have known was there, given that they lived just yards away. In addition, their callous disregard for the safety of others was shown by their failure, while the victims were being incinerated in their car, their failure to show any remorse, concern, try to help, or even to inquire about the condition. Instead, they tried to remove evidence. The court indicated the appellant, Mr. Canizales, was fully aware of the condition of the accident scene, which would make racing there very dangerous. They had long resided in the neighborhood, within yards of where the fatal crash was placed, and inferentially knew the residential nature of the neighborhood, the traffic conditions, and other factors. Mr. Canizales was seen driving recklessly in the area just before the collision. The court in Canizales referred to Justice Gilbert's remark in the Moore case, which the counsel also discussed at 187, Cal. 937 and 941. Whether Moore was subjectively aware of the risk is best answered by the question, how could he not be? It takes no leap of logic for the jury to conclude that because anyone would be aware of the risk, Moore was aware of the risk. It doesn't common sense at all. How could he not be? Going back to the Canizales opinion, the Court of Appeal stated the trial court pointed out that they were engaged in a speed contest at 80 or 90 miles per hour. How much more knowledge do they need? They've got several thousand pound vehicle, but they're running at 70 or 80 miles an hour. What does it take for a person to understand that what they're doing is inherently dangerous to human life? Now here, Mr. Bohm was not involved in a street race with another person, but he certainly was driving at an absurdly high rate of speed with a data collector in his own vehicle. He also not drunk any alcohol, although Mr. Canizales was not stated to have been under the influence either. He just consumed some amount of alcohol. Just as Mr. Canizales was very familiar with the area in which he was driving, so was Mr. Bohm.
He differentiated being under the influence and drinking some alcohol because it's not illegal to drink some alcohol and drive, but driving under the influence is illegal.
By his own admission. Canizales was aware of the conditions of that roadway when he was driving like he did so dangerous to human life, and he likely would cause death, and so was Mr. Bohm, due to his own familiarity with PCH. It should be noted that it was also a factor for the court in Canizales that the defendant's post-crash conduct was deplorable, and that played into their evaluation of his subjective awareness and his callous disregard for human life. Mr. Bowman must be noted demonstrated no such callousness after this accident.
Like, yeah, he didn't do anything horrible after the accident. He throws him a bone there.
The Moore case, which I quoted some of a minute ago, also was instructive, I believe. In that case, the defendant drove through city streets at excessive speed. He passed one victim going 80 to 90 miles per hour in a 35 zone, ran a red light, collided with another car, which in turn hit a third car, causing the death of one victim and serious injury to another. The defendant did not get out of his car, shot down the victims, and continued to drive. When he was arrested, he claimed he didn't intend to kill anyone and did not experience any mechanical failure, but he simply going too fast. And he admitted that he left the accident scene in some very callous manner. The defendant had conceded in front of the Moore case that the evidence was sufficient to support finding a gross mitigated negligence, but claimed it was insufficient to show the subjective awareness of the risk for manslaughter.
Oh no, somebody's trying to like the video and it's not letting them? Refresh, and try again.
After this claim, he stated, Moore drove 70 miles per hour and 45, crossed into the opposing traffic lane, caused oncoming drivers to avoid him, ran a red light and stopped the car in the intersection, driving and attempting to apply.
Repeating a lot of the facts of the other cases they already cited, not as important. That's why I've sped it up a little bit. We're almost done, and I got to run here. So, and there's a couple questions I want to answer at the end.
His actions went well beyond gross negligence. He acted with one disregard of the near certainty that someone would be killed. Not yet more, page 941. When I think about this, how is that so different from the evidence presented at the preliminary hearing in this case? It's not exactly the same. It doesn't have to be exactly the same. Mr. Bohm was driving at the very least 70, maybe it was 80 or 85, and the objective evidence says it was 100 and 45 miles per hour.
Objective evidence says it was 100.
He was observed to be driving erratically, moving from lane to lane, causing another driver to at least attempt to warn him to slow down before he hurt someone or himself. Several other drivers also noticed he was very, very fast driving. One of them, I believe, honking at him. While Mr. Bohm did not run a red light, he did commit very, very serious traffic violations here by speed alone. I don't believe there was any evidence in this case that he applied his brakes either, not in terms of skids or that type of observable evidence of braking. And here, by his own admission, he knew how dangerous.
And he's comparing it to these cases, and he said he thinks it is like those cases. Doesn't have to be exactly the same, but he thinks it is like those cases, which is, again, not good for the defense.
This was his two friends, his best friends, were killed by driving at an excessive speed, extremely excessive speed. And he's very familiar with the PCH. And again, it's only reasonable to assume that due to that familiarity, he knows what the danger zone is, in particular, the area called the Dead Man's Curve, where this accident occurred. The magistrate, Judge Edwards' findings that the elements of second-degree murder were satisfied for purposes of the preliminary hearing were well within the realm of the reasonable. The standard is not a prelim beyond reasonable doubt. That's for trial. I'm not saying what the evidence will look like.
Again, he says they're keeping on the second-degree murder charge with the implied malice.
The case does go to trial. Whether the case will be proven, the murder case will be proven beyond reasonable.
Just because I'm allowing these charges to stay does not mean they're going to be proven beyond a reasonable doubt, which I think is important that he said. Legally, we all already know that.
Nobody knows the answer to that, but that's not a question for today. The question for today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made, the law that he applied, and I do believe that the magistrate's findings were well supported by the facts as they apply to the law that's operable in this case. So the motion is constructed.
All right. The motion is denied. A couple questions I wanted to answer here. RJ said, does upholding the M here blur California's line between implied malice M and manslaughter when speed is the only aggravating factor? Sorry, late to the stream. No, I think what it does is it highlights judicial discretion, prosecutorial discretion, the gray areas, what is left to be defined and understood depending on who is looking at it and reading it, especially when we have the totality of the circumstances type arguments, what fits into these definitions. Words are important. Definitions are important. I think it highlights that more than it's really blurring the lines. Ashley said, what is AJ's next best step trying to get these charges reduced? He can appeal this decision, number one. Number two, again, I think the best case scenario for him is to pitch it to the new DA that this is inappropriate, reduce the charges, charge this appropriately, and then let's go to battle with the appropriate charges. That's what I would do. Nina said, Peter, what do you think overcharged compared to Koberger? I mean, this and Koberger, there's really no comparison, obviously. From my perspective, I understand how the judge came to his decision. But if I was the prosecutor and Jackson pitched this to me, I would agree 100%. I think I'd have a really good manslaughter case. I'd be very confident with manslaughter. Maybe you wouldn't negotiate big time down on what you think you can get as an appropriate sentence for manslaughter because you'd be very confident in manslaughter. But I think the implied malice charge is just too much. I think it's overcharged. Even though I don't necessarily think the judge's hands are tied by the law, that he had to make that decision, I think it's within his discretion. I would have probably dismissed the higher charges and said this is more appropriate for manslaughter. But I think the most appropriate route would be go through the district attorney's office to have them charge the case appropriately, because we really don't want judges being the ones charging cases. That's a function of the district attorney's office. The prosecutor's office needs to be the one doing that. So if I was the judge, I don't know, it's a much tougher decision than if I was the DA. If I was the DA, I'd definitely choose the manslaughter charge. Peter, my son is a 2L about to present as defense counsel at trial ad right now. Only a civil case, wrongful death. So exciting to be able to help him. Thanks to LawTube. That's amazing. That's exactly what I did. I thought I wanted to be a criminal attorney, and my first case was a civil case. And I was like, oh, this is kind of boring. And then I ended up loving it. And I did the closing argument in that mock trial. So it was fun at competition. We did awesome. And it was so much fun and learned so much. Okay, I got to run. This is an incredibly long video. Hopefully you guys liked it. If you did, hit that like button. Send me whatever you're watching, whatever questions you have. As always, you guys pick the content here. But for now, that's all I got. Till next time, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.